What happens if a store refuses to replace a defective product? Concept: when a product is defective, consumers generally have remedies such as repair, replacement, refund, or price reduction depending on the circumstances and applicable warranty. Remedies derive from contract law, implied warranties, statutory consumer protection laws, and any written warranty accompanying the product. Legal basis: federal and state. At the federal level, the Magnuson-Moss Warranty Act regulates written warranties and helps enforce them. The Federal Trade Commission also issues guidance against deceptive warranty practices. Many consumer rights, however, are set by state law: UCC implied warranty of merchantability, state lemon laws for vehicles, and vary by state. What retailers may do: retailers and manufacturers usually offer repair, replacement, or refund according to warranty terms. They may require reasonable proof of defect or compliance with maintenance instructions, but cannot rely on vague store policy to deny basic legal remedies. Evidence and timing: keep the receipt, warranty documents, photos, correspondence, and any repair reports. Give the seller a reasonable opportunity to repair or replace. 30 days is commonly treated as reasonable in practice and by many courts for informal dispute resolution, though timelines can vary by jurisdiction and by the terms of the warranty. If the store refuses, practical steps: 1. Request resolution in writing and keep copies. 2. Contact the manufacturer if the retailer blames manufacturing warranty. 3. File complaints with state consumer protection agencies or the FTC. 4. Consider small claims court to seek repair, replacement, refund, or damages. Administrative and judicial remedies: if administrative complaints fail, consumers can sue for breach of warranty, express or implied, or for violation of state consumer protection statutes. The Magnuson-Moss Act can provide a federal cause of action tied to warranties, including attorney's fees in some cases. Small claims courts are often used for straightforward defective goods disputes. Example 1. Electronics: a phone fails within the warranty period and the retailer refuses replacement citing no return policy. Document interactions: notify the manufacturer and, if unresolved, file in small claims or contact consumer protection. Example 2. Car, lemon law. For vehicles, state lemon laws often require the manufacturer to replace or refund when substantial defects persist after reasonable repair attempts. If a dealer refuses, the buyer can pursue the state lemon law process or litigation. Practical tips: preserve evidence, act promptly, read warranty terms carefully, duration, required procedures, and escalate to state agencies or small claims before costs escalate. In many cases, a written demand letter gives leverage to obtain a remedy without going to court. Bottom line: a store's refusal does not eliminate a consumer's legal remedies. Depending on the facts, you may use administrative enforcement, warranty rights, and small claims or civil litigation to obtain replacement, repair, refund, or damages.